ruling be overruled in front of the jury.
All right. Mr. Brown?
Your Honor, we would say that that's a comment on the defendant's rights to silence in the Fifth Amendment, and it went beyond what was supposed to be done. What I would ask for, and that was the only objection that I made, but I know for appellate purposes it may be important that a copy of the PowerPoint be made part of the record, just in case I missed objections as well.
All right. Oh, I'm sorry.
Yes. With it. And I think that, so I would ask that part about it. I also think.
And Your Honor, just for the record, State v. Taylor 362 NC 514 is exactly the language of nowhere in any of the testimony during the sentencing phase has remorse been mentioned about the defendant's remorse or and I put Melissa's death. This properly called the jury's attention to the defendant's lack of remorse without suggesting that the lack of remorse is an aggravating circumstance found by the court.
I think there are two issues that come into play with comments on remorse. One is whether it is an aggravating circumstance, and I think that your comment does not place it as an aggravating circumstance. The other is the right to remain silent, which is also implicated by the question of whether the defendant has expressed remorse, and he was advised at an early stage of his right to remain silent, and his decision not to make any statements would be a continued exercise of that right. I agree with you that, as you stated it, it was certainly not improper for you to go down that path, but I'm going to stand by my ruling on it just because I'm not sure that it's clear. I think, for example, a comment on demeanor in the courtroom, things the jury could observe, would be certainly appropriate, but I'm going to stand by my ruling that comments on remorse or the defendant's failure to express to any of the witnesses who testified remorse would be objectionable, and I'll continue to sustain the objection. We will allow or ask that the PowerPoint be marked as a court exhibit for inclusion in the court record. All right. Anything else that we need to take up outside the presence of the jury?
No, sir.
All right. We'll be in recess then until 20 minutes past.
Nice. Stands in recess for less than.
Okay.